Ready, start. In addition to the above crimes, the respondent number 3 placed heavy reliance upon the confidential in-camera statements of two witnesses. On the basis of the crime and the confidential in-camera statements of the witnesses, the respondent number 3 recorded a satisfaction that the activities of the petitioner are fully covered under the provision of section 56 in bracket 1 in bracket A in bracket B of the Act of 1951, and as such warranting his externment. Para. The petitioner preferred statutory appeal against the order of his externment dated 5/4/2022 before the respondent number 2. The respondent number 2 found that subjective satisfaction for the externment of the petitioner was arrived at on the basis of the objective material placed on record. His appeal came to be rejected. The petitioner is therefore before this court. I have heard learned advocate for the petitioner and learned additional public prosecutor for the respondent peruse and record and proceeding. Learned advocate for the parties submitted that in the case of the crime at serial number 2 and 3 could not have been taken into consideration is as such as the same crime on the date of the notice and the order of externment were under investigation. Learned advocate further submitted that the crime at number 2, even if held to be available to respondent number 2, could not have been taken into consideration by the very nature of the said crime. As far as the crime at number 1 is concerned, learned advocate submitted that since the said crime was registered on 14/9/2019, the said crime was still crime for the purpose of this proceeding and not sufficient to establish the live link. Learned advocate further submitted that the substance of his statement of the confidential witness was neither set out in the show cause notice nor in the externment order. Learned advocate further submitted that the statements of the confidential witness were not duly verified by the respondent number 3. Learned advocate further submitted that all the crimes were registered at Gadge Nagar Police Station, Amravati City. Learned advocate pointed out that the respondent number 3 ordered the externment of the petitioner from entire Amravati district and that too for a period of 2 years without recording any reason. Learned advocate submitted that therefore these externment orders suffer from the virus of excessiveness. Learned advocate therefore submitted that there is no idea of any objective material to record the subjective satisfaction for the purpose of passing the externment order. Learned advocate submitted that the order of externment directly affect the fundamental right of movement of person and as such ought to have been passed by complying the mandatory requirement of the law. Learned advocate submitted that the order of externment passed by the respondent number 3 and the order in appeal passed by the respondent number 2 are therefore required to be set aside. Learned advocate public prosecutor for the respondent submitted that the continuous indulgence in the commission of serious crime till the issuance of show cause notice waited with the respondent number 3 to record the satisfaction that the movement and act likely to cause danger or harm to the person or property. Learned APP on the basis of the statement of the confidential witnesses submitted that same are sufficient to form an opinion that the people from locality are not willing to come forward to give a statement against the petitioner by reason of apprehension in their mind with regard to the safety of their person or property. Learned APP submitted that the crime registered against the petitioner under the Indian Penal Code were serious in nature and as much sufficient for his externment. Learned APP further submitted that the statements of the confidential witnesses were duly verified. Learned APP further submitted that respondent number 2, an appellate authority, has examined the entire record in the appeal and found that the subjective satisfaction recorded in the respondent number 3 was based on the objective material. The learned APP, in short, supported the impugned order. In order to appreciate and deal with the rival submission, I have gone through the record and proceeding, in this case relying upon the provision of Section 56 of the Act of 1951. The externment order is passed. Stop.